Well, good afternoon, everyone, and welcome to the Texas and Southwestern Cattle Raisers Association May Ranching 101 event. We see many of you are popping on now as we kick off this webinar. First, I just want to do a few housekeeping announcements for those of you who are looking forward to some other educational events that we offer at the association. Our next Ranching 101 will be held Tuesday, June 15th. At 1 p.m. And that topic will be nutrition, what a cow really needs throughout the different stages of her life. That Ranching 101 session will be hosted in part with the Livestock Nutrition Center and the nutritionists on staff there, Levi Trubenbach and Justin Axman, will be speaking about a cow's nutritional needs on June 15th. Additionally, coming up, we've got the Cattle Raisers Convention and Expo, which will be held July 23rd through 25th at the Fort Worth Convention Center, and we would love to have so many of you join us there. Registration is now open at cattleraisers.convention.com for that convention. Without further ado, we will begin our session for the day here. Our session today is Your Land, Your Legacy, and the Law. And we have got Joe Patronella, who's an attorney with Capital Farm Credit, who will be giving our presentation today. If you have any questions, I would encourage you to drop those in the Q&A box or chat box below as we go throughout, and then Joe will answer those questions at the end. So again, if you have any questions, please drop those in the Q&A box or the chat box below. Joe, I'll turn it over to you.
Thank you, ma'am. Before I begin, I'd like to thank Emily, Jason, and everybody over at TSCRA. That's a mouthful for me. I always want to throw a W in there for the Southwest, but I think I've got it down just about. Thank y'all for letting me be here today, and everybody that's logged in. Thank y'all for taking the time to do so. Hopefully I can glean some knowledge your way at some point or another. Just to get a little background, as Emily said, my name is Joe Patronella. I'm an attorney with Capital Farm Credit. Before that, let's see, I graduated from Texas A&M in 2007 with a degree in ag business. Went down to Houston to get my law degree from South Texas College of Law. Turned right back around and came to Bryan to practice law. Did kind of a general civil estate planning, real estate, business, transactional law practice for about, I think it was 8 years, and then got my dream job at Capital Farm Credit. I'd always kind of known the guys that worked at Heart of Texas, PCA, and a couple of the other land banks that merged with Capital, but as you'll see today in this program, we're not going to do a bit of math because my brain is not wired that way. And so I never really thought I'd have a job with Capital or another land bank, but turns out they needed attorneys. So I'm an in-house attorney there, and what that means is that about 80% of my day is spent looking at title commitments. It's enthralling. No, I really love it. And I make sure that, you know, our collateral, me and the other attorneys, it's not just me, we have a whole legal team. We have good access. We have a good first lien position. Our loans are clean, and that we're going to have a good life with the loan. So that's a little bit of my legal background. In addition to that, I grew up here in Bryan College Station, not only going to A&M, and I'm a fourth generation cow-calf producer. I always tell people I'm only an attorney so that I can afford to be a cow-calf producer. So I'm probably, if you'll allow me, gonna sprinkle in a little bit of that experience as well. So that's just a little background on me. And before we really start to dive in, I want to go over just briefly the actual title of this presentation that I've put together. I titled it Your Land, Your Legacy, and the Law. And lawyers are kind of nerds, and words matter to us. And so I want to put emphasis on the fact that I put law last, because oftentimes I think individuals get really caught up in trying to make the law really hammered into their operation, when they really need to just make their operation the chief focus of what's going to work lawfully. So for instance, if your neighbor has an LLC, That doesn't mean you have to. There's reasons that they do, and there's reasons that you don't, and that's okay. So we're going to go through a lot of different things today, and I'm fixing to give you an overview of what that is. But don't think that just because I'm giving examples of one thing or another, and you don't have one of those, that's wrong, or that someone else has that means that they're wrong and you're right. There's a million different ways to do all of this. So that's kind of just a little aside I wanted to start out with. As any good lawyer would do, I just wanted to throw out there that this is for educational purposes only. I know we're, doing this over Zoom. I'd like to think that if we were in the same room, we develop some kind of rapport, maybe a relationship, but it wouldn't be an attorney-client relationship. I do work for Capital Farm Credit. And so everything we're going over is just going to be a general understanding of the law, just kind of general guidance of what I've gleaned and learned over my 10 years in practice. So if any of these issues are arising for you, I would implore you to go get specific legal advice from an attorney, probably a local one in your area. And just a little fun spoiler alert. So we are going to cover legal issues and we're going to cover law, but we're not going to cover the law, which is probably a confusing statement. And what I mean by that is I'm not going to sit here and cite case law from 1882. I'm not going to cite certain statutes. I've gone to enough CLEs and I've done enough presentations to know that you're going to be asleep within 5 minutes if I'm doing that. I would probably be asleep within 5 minutes if we were doing that. So I'm just going to give you practical advice and thoughts that I have practiced and seen in my time practicing. So if you were looking for an update on House Bill 365 on the Farm Animal Liability Act, I'm sorry you came to the wrong Zoom, but I do have to keep up with that for our legislative tracking at work. So if you want to shoot me an email, I'll be glad to share that with you. So just kind of an overview, when Emily and I were talking about this, my understanding of the target audience for Ranching 101 course was individuals who are either just getting into the farming and ranching business or individuals that maybe grew up in it, got away, and are getting back in. So I kind of thought to myself, if I was in those shoes, what would I want to know? And so it's kind of hard to differentiate those two groups. I just kind of lumped it together. So what I was thinking is we can kind of go through knowing your land and knowing what you own, know how you're going to own it, or kind of how you're going to hold it, how you're going to take title to it, know what you're going to do with it, and then know what could happen to it while you're owning it, and then know who you're going to leave it to when it's all said and done. And, lawyers are kind of molded. Most people would not want to go over that last slide, but that's an inevitability. So there's some estate planning stuff that I'm going to throw in at the end that I just think everybody should know. So with that, and another sip of water, we can jump right in. Know your land, know what you own. So, and I'm going to start just from ground base here, because there's somebody that might not know what any of this is. So don't think I'm talking down to anybody. I didn't know what it was when I first started practicing. They don't teach you anything in law school. You learn it by working. Get title insurance. If you're getting a loan, you're going to absolutely have to have that. Your lender's going to make you. But if you're getting a cash deal, I would still think it'd be good to get a title policy, just so that you can ensure that what you're buying from the individual that's selling it to you has record title to sell it to you. In terms of getting a survey, sometimes your lender might not require it. I would still get one. I would definitely get one if it was, a cash deal. You might have a boundary line that's a creek and some of the shoreline might have accreted off, and so you are getting less acreage and you can end up paying less. Or, there's a fence and it wasn't built on the actual boundary line, and so there's more acreage for you, or there's less acreage for you. So I just think a survey really always helps cleanse things up. In terms of an appraisal, once again, a lender's going to require you to get that. But if it's a cash deal, or even if it's an estate partition and you're inheriting the land, you know, I still think it's worth it. If you're getting a substantial amount of land that you're inheriting, it's probably worth the $2,000, $3,000, $4,000 to get the appraisal to make sure that you're getting an equal amount as the other beneficiaries in the will or heirs to the estate. So those are just kind of things that I think are worth going the extra mile to get to know that you know your land. Knowing your deed history, I kind of put that one in there more for the reservations, excuse me, the restrictions. Reservations could probably gone down under minerals, but I look at restrictions every day, like hundreds of pages of restrictions. I have a wild job. Most of the time, you know, we're talking cow-calf operation, somebody row crop farming, so that's pretty standard, right? But every once in a while, somebody wants to do a hog farm or a chicken farm. I can't tell you the number of times I've seen restrictions where that's just not allowed. And so if that's what you want to do, you may not be allowed to. So I would just in the negotiation phase of buying, just say, hey, are there any restrictions on this? Because you don't want to buy it and then not be able to do what you wanted to do with it. For the minerals, if you're lucky enough to get them in this day and age, I would just want to make sure that you know exactly, first of all, what's intended by what's being conveyed. And if you're negotiating with the seller and they say 25% of minerals, well, do they mean 25% of everything or 25% of what the seller has? Because that can be a big difference. And the only way of knowing that fully and truly is getting a mineral history title run done. A landman's probably gonna end up doing that for you. You could probably get that done through a regular title company, but then you're gonna be doing the work through the deeds, and I would just get a landman to do that. Access. Oh boy. There's a million different ways to go about this one, but just make sure you have it. Because that road that you always use to get in this place might not be a road. You know, is it a public road that you've been using? Is it a county road, or is it a private road that then is going to still require an access to a public road? If you're getting financing, you're going to find out because the lender is going to require you to. But it's just, it'd be better and less heartburn on you and your lender's attorney if you did so at the beginning. But we're always glad to help at the end. Because if you have it figured out at the beginning, then you don't have to get it and then risk being landlocked and then suing for an easement by necessity or any kind of other easement, where then you're going to court and you're having to prove up whether it's validly proved that you need it, and risking attorney's fees and court costs, and at the end of the day, maybe not getting it and then being landlocked. So I just always stress to people that access is probably the most important thing that you can figure out when you're buying the tract, if it's not clear that you are on a public road. Okay, so we kind of know our land, we know what we have, so we kind of need to know how we're going to hold it and how we're going to own it. Are we going to hold it individually? There's nothing wrong with that. I feel like a lot of people feel that to limit their liability, they have to have it through an LLC. Well, I mean, yes, that will limit your liability, but there's pros and cons to both. You know, a lot of people put in an LLC because they're doing something pretty risky with it. They have a game ranch. Well, there's a lot of guns out there. There's a lot of fire. There's a lot of things that make them need that. If you're just running cows on it and you're the only one ever out there, maybe you don't need one. Maybe you do, but maybe you don't. You know, the LLC is kind of the entity structure now. You know, it was a corporation before that. You know, people were kind of using LPs. The LLC, it's really easy to create. There's good tax benefits. It's flexible in management style. You can have it set up so that it's managed by managers, and as long as you don't change those and you're just swapping out members, you don't ever have to change what's with the Secretary of State. So it's super easy. I love an LLC. But once again, you might not always need one based on your situation. The pros to them, like I said, they're good for shielding liability. There are tax advantages, you know, from an estate tax side. You can get, if you're near the state tax limit, which we'll go kind of about that towards the end, you can get larger assets of land out of your name and put it in the LLC, so then your estate tax burden goes down. That's good. Income tax wise for an LLC, it can be taxed as an S corp. This is the part where I'm going to jump in and say I am not a tax attorney. I'm not a CPA. And so in making any sort of tax-based decision, consult them. This is not my legal advice to you on that. The cons for creating an entity are, once again, was your risk for liability so great that you needed the entity? Because, for instance, on an LP, a limited partnership, all right, to manage the limited partnership, you have to have a general partner. That general partner is typically another entity, an LLC. So all of a sudden you become pretty entity rich, and now you have to keep the LP documents, the general partner documents, which are an LLC document, and then your own personal documents, simply for what? Was the risk great enough to now have all this administrative burden? So you just kind of have to weigh that out. And then also, another con is that if you're going to run your primary livelihood through the LLC, salary payments can kind of be tricky for LLCs and partnerships. And that is definitely something that a CPA should be consulted on. So going back to my original point, just because someone else has an entity, doesn't necessarily mean you do. You have to really think about, is it worth it to me to make that step to change the entire way I'm running my business simply because I want to shield some liability? You have to weigh that risk. Probably just scared y'all to death. Okay, so now that we know how we're going to own it, we need to talk about what we're going to do with it. And first things first, we need to claim ag on it. And I'm using quotation marks there because that's a slang term. I've used it my whole life and I will continue to use it. But really, when you claim ag to get an ag exemption, you're not really doing that. You're lowering your taxes and tax rate by using either the ag use valuation or the open space valuation to lower your tax rate. The ag use valuation is pretty stringent. It's what a full-time farmer does, someone who's getting his primary income from that. And that has to be applied for every year. My family, like I said, is fourth generation, and we have what I think is a pretty sizable operation. We don't do that. We do the open space valuation. That's the vast majority of land in Texas, is the open space valuation. That is a one-time application, and that's anytime land changes. So when you buy a piece of land, you have to apply for that. When you inherit a piece of land, when it comes from your folks or grandfolks or from whoever, you have to apply for that. Much further than that, it gets pretty county specific into the degree of intensity generally accepted into that area. So there's various different rules within the county that have to be abided by to ensure that you are going to obtain that open space valuation. So it's prudent to get with your central appraisal district. I'm sure the majority of you already have it, but you know, those of you that don't, and those of you that don't know about it, make sure to do that. All right, so we've claimed ag on it. What are we going to do with it? For those of us that are in the love of the game, we're going to operate it. So let's talk about ranching it. I'm going to take my lawyer hat off for just a second because, you know, I prefer to have a ranching hat on. Are we going to have some Hereford bulls and put some Hereford cows, put some Hutchins bulls on them, raise some Brayford heifers, and are we going to turn around and put some Angus bulls on those and wean those calves and background them for 60 days? Or, what are we going to do here? We need to have a plan. We need to make sure that we're going with what is best for us, and kind of like with those entities, not what our neighbor's doing and not what we did in the past. Because, what my family does today is drastically different than 5 years ago. And what we did 5 years ago is worlds different than 10 years ago. So you've got to be okay to evolve and change with not sticking with the same game plan. And at the same time, you have to know your limits, because your neighbor's going to sell those calves straight through the sale barn. You might background your calves, and then your other neighbor might retain ownership through the feed yard. I don't have the capital to keep them through the feed yard, but I know that I don't want to sell them through the sale barn. All three of us are doing it our own best way. None of them are wrong. So just, know what's best for you. And then, know what you know and utilize that within your operation if you're lucky enough to have partners. My dad can probably tell you what we booked feed at in 1997. I can't tell you what we booked feed at in 2019. But conversely, I can tell you what heifer calf from number 343 is at what place right now and what calf she had this year. I'm just kind of really better at the management side. So utilize your strengths with each other. There will be fights that come with that, but work through those. Okay, so if we're not going to ranch it, maybe we're going to farm it. I don't know a thing about that. I don't have the desire to know a thing about that, but I'm happy for those of you that do. I'm talking to a group of cattle raisers, so maybe I'm not alone in that, but I wish you the best if you are going to farm. So if we're not going to operate it, and we're going to lease it, because maybe you have sense that you don't want to be out there pulling heifer calves or having to replace bulls because they're fighting, and you just want to be a landlord. You're probably smarter than all of us that are operating. So just a couple of general terms, because I'm going to go through grazing. I am going to go through crop leases and hunting leases, but a couple of general terms that I've always put into leases when I was drafting them, because the lawyer hat's back on now. It's got to be a written lease. I try to see the good in people, but when there's a dispute, the good in people starts to go towards themselves and not towards you. Days of a handshake are gone. You just have to have a written lease. I like to have a set duration in the lease. I don't like for there to be an automatic extension for two reasons. It kind of keeps everybody on their best behavior. It keeps the landlord from kind of being absent-minded and not, paying attention, and it keeps the tenant on their best behavior. So I don't like a one-year lease, because that's a big investment for the tenant to have in terms of getting animals and getting a herd out there. So I always kind of think a 3 to 5 year lease, 5 probably if I was the tenant, maybe 3 if I was the landlord. I don't know. And then also, just from a lender standpoint, an automatic extension on a lease is kind of treated as a preferential right over a first lien. And so, not speaking on behalf of capital, but just lenders in general, that lease may have to be subordinated at time of closing. And I can't tell you how many times that has delayed closings or just become an issue that has to get taken care of. So in general, I like a set duration. It's going to end at 12/31/21, and then you can just turn around and renew 1/1/22. For a grazing lease, specific terms, I like for a monetary amount to be set per acre, not per head. Just makes more sense to me. You're leasing the place, you're not leasing animal amounts. I like for the stocking rate to kind of be in line with standard county ag practices. Here in Brazos, we kind of try to keep it for 1 head per 5 acres, 4 to 6 if you want to say, but I like to average. So, taking that, divided out how many acres you have, how many head. Not going to do that math for you. I told you I wasn't going to. So I would, then say no more than blank head, and that's going to be per cow calf unit. As long as the calf's still sucking, that's a unit. If you're going to have stocker calves, that's a totally different deal. That's a totally different deal. I like to put in there no sublessee, so that the landlord knows exactly who they're leasing to, and they can't turn around and then show up and there's a third party out there that they don't know and they didn't bargain with. Put provisions in there for who's going to be in charge, whether the landlord or the lessee, for the repair, maintenance of fences, pens. Maybe somebody pays for the materials, someone pays for the labor. Have that in there so that then, when inevitably pins get broken when you're working, or a bull goes through a fence, who's going to do what? With a good relationship, it tends to work itself out, but just maybe better to have that in there. I would always throw in a grazing lease, that they can't hunt, because this is a grazing lease. It's not a hunting lease. I've seen where it's both. I don't like that. To me, they need to be two separate documents, but that's just my thought. So these are just kind of the terms that came through my mind as I was putting this together. There are additional terms. You're going to have your standard boilerplate terms in any lease that are at the end that any good attorney is going to have, but those are just kind of the things that came to mind for me right then. Okay, crop. So once again, I don't have any background in crop. I'm a cattle guy, which is ironic because I've got a picture of horses and I got some cotton over in the background, but here's a cow. See, I got a cow. Anyway, so crop leases, I really actually never drafted any in private practice, so I just did a little bit of researching before this, and I know that you can do some provisions for unharvested crops at the end of a lease that, if the lease ends and the tenant still got them in the ground, tenant should get those. And you can have something to protect the landlord to make sure their land isn't being run into the ground for soil fertility measurements. Once again, I've never drafted a crop lease, so I don't know how much that is done in practice, but that is an option. One thing I do know, actually, just from around here and talking shop with some of the farmers, if it's an option in your area and you do want to lease any row crop-ish land that you have, possibly look into specialty crops, because I know around here there's a big watermelon farmer and he will pay about double what the row crop guys will pay. And so that's, to me, that's worth your bang for your buck. The caveat is that, they leach the soil, they're pretty nutrient heavy. And so he can do it 1 year, but has to lay out the other year before he comes back the next year. So in those off years, row crop can be planted. It doesn't have to lay fallow, but you have to find a regular tenant that can come in and do that. So maybe a little more management intensive on your part as a landlord, but if you're getting double the money every other year, I think that's pretty worth it. Hunting leases, the program Emily and I actually met through, it's called TALL. We actually just got back from a trip down in South Texas, and we were at a session with the King Ranch Institute for Ranch Management, and they were kind of going through, what you can get for a hunting lease, and up 24 per acre for a good one, 8 to 18 for average. We've never had hunters on any of our land. Most of it's cleared for cattle. That's just not something I'm real interested in. There's a bunch of hunters out there. But if you wanted to, some of the terms I've seen and ones that I've done, you're going to want to require that they have hunting licenses displayed at the camp house. I would always want to put in there a set number of hunters or stands that are allowed. You may want to consider whether ATVs can be used. That's kind of pretty risky liability waiting to happen, maybe. You may want to consider whether alcohol can be used out there. Whether they're going to abide by that or not is another story, but you've got it in the lease. You may want to consider whether non-hunter guests can be out there. Once again, if you're not part of the lease, or if you're not a present landlord, I don't know that you can control that, but you can have it in your lease. And if it's an accident occurs and you have that in there, you've kind of taken a step to protect yourself. I would put in there something about livestock injury. They go to shoot an 8-point buck and shoot an 8-month calf, probably compensate you. And kind of like grazing, there's additional terms, but those are kind of the key things that I'd want. There is, thirsty y'all, I don't know if it's a database or just a spreadsheet, but the USDA and the NASS, which is the National Agricultural Statistics Service, that's a tongue twister. They put together every year rental rates for irrigated cropland, dry cropland, and pasture land. I would implore you and caution you to look that up so that if you're either leasing or as a landlord or tenant land, you can kind of get a baseline for what land's going for. I'm gonna caution you more so though, because they have the average pasture land in Texas being $7 an acre. And I understand that's, taking into account the Trans-Pecos and also Brazos County, which is like cattle country central. But, we would get laughed out of town if we offered somebody $7 an acre. It's more like 25 here. So I know it's an average, but I even looked up per county and Brazos was still at like 1150. So it runs low. But if it gives you some perspective and some peace of mind, feel free to look that up. Okay. And next slide. I'm not techie, y'all, so clicking buttons even keep up is a big win for me today. Know what can happen to it while you own it. All right, so this is a loaded slide. Clearly, so much could happen to it while you have it. And I'm just gonna try to touch on, I don't wanna say the basics of it, but just go through a little bit and see what's happening. I put the first one first because I know that every single one of you in here wants to know about it, and it's probably irate about it, rightfully so, and has likely been affected by it. So that's great that it's first. The bad news is I'm going to talk about it for like 2 sentences. There are so many single topics just about eminent domain. I see a hand raised, and I'm probably going to keep all questions towards the end if that's all right. So if you want to type a question in the chat, that'd be great. There's so many single topics on eminent domain and bills going through about eminent domain that, I'm just going to give you my general feelings on it and we can just kind of move along. This is happening every day in every county, everywhere in Texas. It's unfortunate that it's going to go through your land, but it is going to happen. So I understand that that's going to be an emotional issue for you, and I don't blame you if it happened to me, and when it happens to me, it will be as well. But you can't bury your head in the sand and you can't not do anything about it. I'm not saying the timeline is fair. I'm not saying it's not fair, but you have numerous opportunities before it actually goes to a judge and you have a judgment of eminent domain against you to fight this thing. And so get in the fight early and get what you can out of it before a judge just hands it to you. You can contact an attorney the second that you get that notice from that company that's been granted eminent domain rights and negotiate against them. Start there. If you can't work anything out there, you have the right to go in front of a special commissioner's hearing, which is generally 3 individuals in your county that aren't elected officials and that can, maybe hear your case a little better than a judge. Nothing against judges, but there are ways to go through it. So just get in the fight early. Boundary line disputes. I mainly put that up there just because this is typically going to come up, and I see this a lot actually on title policies and commitments at Capitol. You've got two parties that have owned land together for decades, and one goes to sell it, and in the new survey, the fence is off. Usually it's a matter of feet. The survey was either done right and the fence builder was off, or the survey was done wrong and the fence was right, and there's just a dispute. My take on this stuff usually is try to go about it civilly. If it's usually a matter of feet, and you can have a boundary line agreement that states, hey, we understand that it's off and the actual boundary line is here, but the common boundary line is this fence, and we agree to that. You're avoiding a lawsuit that's not going to get you anything but a nominal amount of land, crazy attorney's fees, and a hacked off neighbor. So what that also does is the boundary line agreement also avoids any adverse possession claim, because you're both agreeing that of the use of the land on the other side, and so everybody knows that the land is still there, so that if the fence ever was built, it can be built on the exact side of whoever owns what land is on the other side that isn't theirs. Wind and solar leases. So very much okay with one, very much not okay with the other. I'm a real black and white guy. There's not much gray. And no offense to either person that may be in either industry. I'm just speaking on behalf of my love for ag. So pro wind, and I will also say that that's really easy for me to say because I'm a NIMBY there. They're not in my backyard. That's a term we learned in law school. I don't have them in Central Texas, so I don't have to see them. I don't have to deal with them carving up my land. So they're just kind of a part of South and West Texas landscape to me. But aside from that, they don't ruin your ability to still do productive ag on the land. You can still row crop around them. You can still run cattle. You can still do whatever you were doing. They typically have about 30 to 45 year terms, so it does lock your land down for a while. And from what I understand, I've reviewed these leases for Capitol. Since I didn't practice in West or South Texas, I never negotiated them. They have a 4 to 6 royalty rate, so that's just an objective statement I'm making. I don't know much about it otherwise. The things that I have seen in reviewing them that should be careful about, kind of like in a grazing lease, these wind companies will try to put in automatic extensions. An extension in a grazing lease for 3 to 5 years is a little bit of an easier pill to swallow, even though I don't like it, than an automatic extension for a 30 to 45 year term on a wind lease. So if I was going through what they've offered me, I would try to strike that automatic extension or make them pay me very well for it. The one thing that I would really fight them on, and not all of them do it, a lot of them have learned to take it out because most lenders will not accept it. Once again, not on behalf of Capitol, just lenders in general. They try to put in a right of first refusal. So it's just a wind lease, and they're just putting these towers up. But they have snuck in these right of first refusals where if you ever go to sell your land, they have the right to buy it before anyone else. That's a no for me. Personally, just because if I wanted to sell it to my cousin, my uncle, my friend, I'd rather do that than the wind company. But it's a problem for a lender because it, much like a lease, well, it is a lease, but much like a grazing lease that isn't subordinated, if this doesn't get subordinated, it's viewed as a preferential right over our lien, and so it has to get subordinated, and they're usually good to work with, but many ag lenders that ends up being a problem for. So it could end up ruining a deal for you, is what I'm saying, if it doesn't get subordinated. Another thing that you maybe try to have put in those leases for wind lease is a decommissioning requirement where, at the end of the project, they come and take those down. I don't know how practical that is in real life. If that company goes belly up, I don't know what money they're going to have to come take those big things off your place. But overall, I think a wind lease is much better than a solar lease. And I'll tell you why there. Solar, these wind leases you can still produce around. Solar, they take up 80 to 90% of your land. I'm not sure where you run your cows. I don't know where you can plant your crops. So, I mean, the answer to that is you can't. So, not only does that hurt my production agriculture heart that you can't run your operation, but it also hurts my tight Italian wallet because you're about to have to pay a whole bunch more in taxes because you can't claim ag anymore. And so unless you've expertly negotiated with them, the solar company, to compensate you in what you were going to have to pay in taxes, which they oftentimes, from my understanding, won't, it's really not worth it. And then, once again, not speaking directly on behalf of Capital, but ag lenders across the board, and speaking with other ag lenders and Capital, they will not, most times, finance land that has a solar lease on it because it's not being held for ag purposes, and that's one of our main requirements. So it's just, I don't see how it's feasible for ag productive land. But just so that it can't be said that I'm completely biased, if that's something you want to do, from what I understand, for leases that are done on a royalty rate basis, it's between 3 and 4-ish%, so a little bit lower than a wind rate. And then if it's a per acre rate, it's anywhere between 200 and 700, so it's kind of all over the board. So that's kind of my spiel on solar. And then oil and gas, I did this while I was in private practice. I've been out of the game long enough to not know exactly what the rates are. I think you're probably still getting around a 22.5 to 25% royalty rate. Main thing is, if you're gonna have a surface lease, I would always try to use a separate surface use agreement from the actual oil and gas lease to make sure that, you hold their feet to the fire on acreage compensation, size of the pad, fencing, environmental controls, livestock loss compensation, whole kit and caboodle. Just that way it's really its own thing. I mean, it can be attached to the lease, but I always liked it, kind of up front. You're going to want to define operations, have depth severance clauses where at the end of the primary term, whatever they haven't produced underneath, that proration is released so that then later it can be maybe leased to another company. I've had that happen with clients and then they're really happy. Any pipelines that they have to use to get stuff out of there, I always try to get it 48 inches as opposed to the common 36. Because then if you ever need to come in and build a road, if you want to develop it later on, road can go over 48, can't go over 36. No hunting by workers, require all spills be cleaned up immediately, H braces on post, cattle guards closed, gates how you found them, just typical stuff like that. So, and then, like I said, this is a loaded slide because there's so much that could happen, but there's so much more that could happen. Any and all of that, most of the time is going to involve negotiations. So just as a general reminder, and y'all probably know this, but their first offer is not going to be their best. They'll have more, so go back and ask for more. Try not to be the first to sign, but don't hold out long enough that you get left out. Because if you're not first and you wait a little while, then maybe pay you a little more, but don't get left out. And then try to make it work for you if it's going to have to happen to you. So what I'm saying there is, if a pipeline comes through, whether it's from eminent domain or if it's just a boundary line, not a boundary line, but a pipeline negotiation as a private company, try to make it a non-exclusive pipeline so that if another company comes through, they can plop theirs in there too, and you don't have two different easements that are cutting up your land. Or, if that oil company has to build a road to get to the pad, make it meander where you wanted it to. Maybe they build a bridge over a part of your place that has a washout. I don't know. Just I've had all those little things happen while I was practicing along the years. See if you can make it work for you if they've got to do it anyway. But for all of it, I would contact an attorney, and a local attorney at best. I think a lot of times people think that an attorney in Dallas, Houston, or Austin is going to do it better for them because, they're a big city attorney. I have friends that work in those firms, and that's great, but they don't have the boots on the ground, and they don't know exactly what, Mason County is getting price per rod, or they don't know what Burleson County is getting royalty rate per acre, because it differs by county. So I always advocated for, local attorneys. Okay. And lastly, know who we're going to leave it to. Which, like I said, depending on, where you're sitting in life, it may seem like it's years from now, or it may seem like it's tomorrow. Hopefully not. But either way, you need to have a plan. And I think a lot of people feel or have heard that they may need to trust. I got that question so often when I was in private practice, and I did a lot of wills, and I hardly ever did a trust. And so the rationale for that is twofold. Probate in Texas is not scary like it is in other states. It's actually really easy. They've really streamlined it. The hardest part of it, when I say hardest, I mean the most time intensive, is waiting on the death certificate from the Department of Vital Statistics. It takes probably 2 to 3 weeks. Once you have that, you do an application for probate. I think you wait a week, maybe 2, and you're in front of a judge for 5 minutes to prove up the probate. You get an order admitting will to probate and what are called letters testamentary, and then present those to any financial institution, transfer monies, and then you do a distribution deed. Some people call it an executor's deed, but I always like distribution deed because it's alliterative. And you transfer the assets out of the estate. Kind of about it. So it's not burdensome. It's not hard. It's a pretty simple process, streamlined. So that's the first reason why I didn't ever really refer clients to trust. The second is that with the estate tax limit being so high, it's 11, I think it's 0.58, but just, don't quote me on that, 11 something million per person. So that's 22 million per couple. That's a lot of money. So unless you're over that, you don't need to have a tax planned will that then pours over into a trust. So, feel free to consult a tax attorney and a CPA and make sure that you don't, because you know your assets better than I do. But that was always how I was trained and what I was brought up legally to do, and that's how I did it. So I always just had individuals do a will. You have your beneficiaries who you want things to go to. Kind of one of the agrarian provisions that I would put in was a right of first refusal for any farmer ranch land or assets. So when I say assets, I'm talking like the cattle herd. I would make sure that, sometimes there's individuals that live the land and sometimes there's individuals that have gone off and not, and that's okay. But I would typically give everybody a fair shot to have a right of first refusal to purchase the others out so that it could stay in the family. So that's always something that I did to make sure that that was in there. So you have your beneficiaries and any provisions to try to keep the farm together. Then you have your executor who's going to make sure to leave it to who gets what. And then you have, if you have any children, you need to put a guardian provision in there. The one trust that I ever would do is you can put a discretionary trust within the will. Doesn't have to be a separate document. And it's just so that if there's a death of both parents, that any child under the age of a certain, like 20, 18, can have assets held for them and distributed by the executor. Because I know if I got monies under 20, that would have been pretty. I would have just bought a million double cheeseburgers. The alternative to having a will, oh, nope, going back. See if you click your mouse, that's the next thing. How about that? I learned something. The alternative to having a will is to do nothing. I would ask you not to do that. It's not the end of the world, but what you have to do then is it's on your heirs. So under a will, you have beneficiaries. Under an affidavit of heirship or a declaration of heirship, you have heirs. And that's when you don't have a will, which is nothing. So you have to have your heirs kind of take it upon themselves to get two disinterested witnesses to do an affidavit that states they know your marital history, your familial history, and attest to that and get it signed. And then the affidavit is just recorded in real property records, and property can be transferred that way. For a little bit larger estates, you can go in front of a judge and get a judgment or a declaration declaring heirship. It's just a lot simpler if you get with an attorney beforehand and do a will. And then go through the probate process. That's my experience. And then I wouldn't be worth my salt as an attorney if I didn't tell you to just go ahead and while you're doing the will, do a few additional estate planning documents. It doesn't have anything to do with Ranching 101 necessarily. But you know, directive to physician and POAs, directive to physician that deals with life support. I'm not getting into that. That's a very personal decision. Y'all can discuss that amongst your significant others. And then powers of attorney, medical power of attorney, durable power of attorney is for property decisions. Just lets your agent that you appoint act in the event of your incapacitation. So that's kind of what I have for y'all today. Kind of flew through some stuff. Hopefully it was worth something. In closing, really, I've already made these points, but make your operation work for you, not someone else's work for you or yours work in the way someone else's works for them. There's no one size fits all. Everything's going to be different. Everybody's is. Maybe easier if it all works the same, but it's kind of the beauty of it. And then I mentioned that program Emily and I are in together and how we met each other. And what we do is we go to different regions of Texas and we hear from different producers. We were in South Texas this past time back in the fall when we were up in the Panhandle. And one of the quotes we always hear is, just because it's always been done this way doesn't mean it has to always be done this way. And I don't know why, but it always sticks with me, and probably because half the time it's from guys in like their 70s. And they're continuously innovating and they're continuously evolving. And I just think it's really neat. And I hope that at that point in my life, I'm still learning more. I'm just gonna leave y'all before we get to the questions that I know are up there with some miscellaneous resources right quick. For anybody wanting to look into whether they need an entity or not, the Secretary of State has a really good site. It's called SOS Direct. I probably in hindsight should have put the actual link, but just Google SOS Direct Secretary of State. It's got all the forms and all the information you need on whether you want an LLC, an LP, etc. TexasProbate.com. His name is Glenn Karish, and he's kind of the, at least in my opinion, the reigning source on Texas probate law. He's got those POAs I talked about and other forms. He's got a disclaimer on there, just like I did before this, that it's, you know, use at your own use, but I've used them for years and never found a problem. Oil and Gas Lawyer blog. I don't even know this man's name, but I've always thought he has good insight. And he's kind of got I think he has, it's called a Checklist 101 for negotiating oil and gas lease that you could look over and know kind of what to talk to your lawyer about. Landowners Bill of Rights. It's got that's some good information for if you're faced with eminent domain. Gives you some good resources there. Once again, still get with an attorney. Ag Law in the Field. This is a young woman named Tiffany Lashmat. She works for Extension, and I had to write that link because I don't even know how you say it, but she has some good content. I think there's some blogs and such that she covers a lot of different issues. She gets into a lot of statutes and cases and stuff that I don't really get into. I'm more practical, but she has a lot of good content if y'all wanted to look into that. A lot of ag law there. And then, like I said, local attorneys and then local producers. if you're just at the co-op and getting feed and you see somebody that looks like they know what they're doing, ask them a question. Ag is a really friendly community. They're probably gonna want to help you. They might give you some insight that you didn't know. I learn from people every day. I want to. NRCS, FSA, you'll probably know about that, but you know, NRCS is assistance program. FSA is like drought and freeze monies. I mean, NRCS, they'll help you cross fence, brush clearing, that kind of deal. We've done some of that. It's worth it. And then the last thing, I don't know that a lot of people know this, but the Texas Department of Ag has a really, really worthwhile young farmers grant. I've gotten it a couple of times, and not to sound like an old codger, but back in my day, it was a lot less substantial than it is now. And they've like tripled, if not quadrupled, the amount of money you can get. So I would definitely check that out. Just Google TDA YFG even, and it'll come up. They usually do one in the spring and the fall. I think the fall one comes available in June. So you probably right about beforehand when you can do it. But they've got a really, really helpful staff. Mindy Fryer, I think, well, old buddy David always helped me. She's great. She should be able to, or any of them there really are good. And so that's really all I've got. So I think dear Emily is going to help me get back to the, or maybe they're here. Let's see. Oh, okay. Here's some questions. Question time. Okay. I'm a rising 3L at South Texas and third generation cow-calf producer. What advice can you give to a young lawyer wanting to stay involved in ag? Hi, Jenny. We sound like we would be friends. So first of all, I would focus on the bar, like really hard, like really, really hard, because that's going to be the worst summer of your life. I actually, funny story, I took the bar in 2011, and as a lot of y'all will remember, the bar or 2011 was like the worst drought ever. And I didn't leave the law library, like 18-hour days. And you may be smarter than me. It might not take you that long to study for it. But I came home in August after taking it. And it was like Simba coming back to the Pride Lands. And I was like, oh, Dad, it's been bad. And he was like, yeah, I tried to tell you. So focus on the bar. But, you know, I don't know where you're going to be practicing or where you're going to be living. But what I did is I did get involved with my local bar association. And I kind of knew that I wanted to be involved in ag. It's a hard thing to do depending on where you're going to be living. Like in College Station, you can't specialize because it's kind of a smaller market. So I had to do everything, but I chose an area of law where I could specialize and still do ag, because I've never held myself out to be an ag lawyer. It's a very hard thing to do unless you live in like the Panhandle, right? Because that's all, I don't want to say that's all there is up there, but it's easier. You work with a feedlot directly. But so here I did transactional because I could still do real estate, and there's farm and ranch sales in real estate. I could still do wills, trust, and estates. Like I said, there's provisions within wills, trust, and estates where you're specifically working with ag families. So I made a system that maybe not allowed me to specialize, allow me to do areas that still allow me to get as much ag experience as I could. So I hope that answered your question. All of you, if I don't answer your question, I would please welcome you, and anyone who doesn't want to ask a question here, because I'm actually one of those people, I don't like to ask questions on these. I like to follow up later. I just feel that I get my thoughts better later on. Please feel free to email me at joe.patronella, PATRANELLA @capital, CAPITAL, capitalfarmcredit.com. And I'd love to talk with you and anyone else more about that. Okay. Michael Kerr, let's see. Okay, Michael asked, my wife is disabled and on disability. I own 350 acres of cattle land as of now, no oil production on it, which I own mineral rights on most of it. My question is, should my will pass it on to my wife or skip over to a grown child of ours? Okay, a lot there. First thing you should be aware of is that if you you should be careful of different tax consequences there for not giving it to your wife and skipping it over into your children. You may not necessarily face the same tax burden as if you skipped it from your child to a grandchild, but by not doing it to your wife, there still could be something there. I would consult your CPA on that. In terms of whether or not you're going to face a consequence in the first part, it may depend on whether you inherited that, or if your wife and you bought that together. If you inherited that, it's probably not going to be an issue at all because that's your separate property and you could just give it to your kids outright and that's just normal. So another thing there is going to be like, how much production do you anticipate during your lifetime? Which is, not a fun question to have to think about measuring that versus the rest of your life. But those are kind of the things that I would take into consideration while you're weighing that out. But as I'll tell everybody, except for Jenny's question, because that wasn't really a legal question, I would consult an attorney about that, but those would be kind of my thoughts in that direction. John, okay, so what specifically did you mean when you said things are way different now compared to 5 years ago talking about cow-calf operations? It's harder to make money now. We would sell our calves straight through the ring without blinking an eye 5 years ago, and we've started backgrounding them to try to cut out some costs of having that commission with them going through the ring, or getting that extra gain from those 60 days where we retain that gain and they go not straight from their mom, but keep that gain in our pocket. And I'm quite honestly not educated enough to tell you. I mean, the price of grain has gone up. I know that there's only 4 packers now, so they can control a lot more of the market up north in the Panhandle, but I don't really know enough to give an entire speech about that. But just the margins have gotten so slim that it's harder on the cow-calf producer to make money. And so it's just that whereas we used to just take everything in the sale barn, we try to at least take 1 load of calves, if not 2, to background for 60 days and sell them on superior.com so that we can try to get as much money in our pocket as possible. So there's just ways that we try to innovate and do things that we have seen others do that has worked for them to incorporate into our operation. Jenny asked, do boundary line agreements survive conveyance? They can. And that is one of the most frustrating things about answering a question as an attorney, is that half the time my answer is, well, it depends. Most times what it's going to be is it's like, Jenny and Joe have a boundary line agreement, and this agreement survives and is for the benefit of all beneficiaries, heirs, parties to and purchasers of the land. Any good attorney is going to draft that in there so that then that's in place for the remainder of time. But I've seen some that it's just written on a piece of paper and it's just those two, and every new conveyance that comes up and the title company accepts to it, so it has to be either dealt with or agreed to each time. So that can be a thing, but most of the time it's drafted so that they do. Okay. Couple of questions on trusts and skipping generations and gift tax. And I honestly don't, like I told y'all, I've not dealt with trusts. So I'm going to punt those to you guys to ask a trust attorney, because I probably drafted thousands and thousands of wills in my private practice. And I drafted even the wills that I drafted would be, even the trusts that I drafted were marital trusts within wills for high net worth individuals. I never drafted separate trusts. So I am going to be unable to answer those questions for you guys. That's just not my area of expertise. What is the normal width of a road easement? 30 is ideal. About 20 is minimal for what a lender is going to accept. Kind of parlaying off of that, in terms of if somebody comes to you asking for an easement across your place, they're gonna ask you for a 50-foot easement. They do not need that. They don't need that, okay? Never give them that. They just want that because it's easier for them to work. What they need is oftentimes a 25 or a 30-foot easement at most, and then they need a temporary workspace easement outside of that they can do the work in, that then can go away after construction. So I'm actually very glad you asked that question, Stephen. Thank you. Never give them a 50-foot easement, because that's there forever. They don't need that forever. They need that to build on. Emily, I think that's all the questions I see. Am I missing anything? Is there another thing in here?
Joe, I think you've done a great job. Thank you so much for joining us today. It does appear that Joe has answered all of the questions. And so if you have any further questions, then I would encourage you, now's your last chance, drop it in the Q&A box or the chat box, or you can email education@tscra.org, and I will forward those questions over to Joe and the team at Capital Farm Credit to help get those questions answered. And as he mentioned, of course, there's lots of resources in your local areas that so many of you can get plugged into and get those answers to your questions from your presentation today. So all of you will be emailed a link with the recording. A few of you have asked for the presentation and the slides, and we're happy to get those emailed out if you'll send an email to education@tscra.org. Joe, thanks so much for your time today. We appreciate you taking time to spend with TSCRA. We hope each of you have a great Tuesday.